In this short video, we are going to understand 7 misbeliefs or 7 misunderstandings about patent that could be stopping you from your future profits or from a chance to overcome the competition in the market. So to get started with the video, let's very quickly go through all of these 7 misbeliefs or misunderstandings about patents, and you may check if you have any of these. First one, we have many ideas or many innovative products in our mind, but we need to build the prototype or working model, or we need to manufacture it so that we can send it for examination. It would be evaluated, and then only we will get the patent. Second one, we are busy in our business. We have different priorities. We don't have time to invest in research and filing patent and getting patent. So we are absolutely busy. We don't have the bandwidth to work on patents. This is the second most common misconception about patent regarding the time required or your bandwidth required to file a patent for your ideas or invention. Third one, this is something I personally witnessed when we visited a client in industry. We do have very good ideas and innovative product ideas, but we don't have capacity to produce it. We don't have machinery, the infrastructure, resources, or manpower to produce it. So what is the point in filing patent for it? Why we should patent it? This is again a misunderstanding that we would be covering in this video. Fourth misbelief, getting patent is extremely expensive and we don't have budget for it. Now this is again very common and we do have answers to it as well. Fifth misbelief, getting a patent is a lengthy and time-consuming process. It takes years for patent to be granted. Sixth most common misbelief, patents are for big technology research-oriented firms. We are a simple plain business and we don't have anything that could be patented. And seventh misbelief, patent is a waste of time and money. Did you have any of these assumptions in your mind? If the answer is yes for any one of them, this video is going to be extremely valuable and profitable for you. Now let's proceed to a very quick and short answers to all these 7 misbeliefs or misunderstandings about patent. And being respectful of your time, we will keep our answers very short and crisp. You must be referring to a PDF research report along with this video, which is an outcome of 6 months of extensive research that we conducted around same topic. And we also have taken wisdom from 14,000 interactions with inventors, research people, and industry owners for filing patent. The information in the PDF report is specifically designed for industry owners, business owners, and management staff, such that the outcome of the research of 6 months of research is arranged in a sequential, logical manner, easy to understand, step-by-step way, so that it will help you clear most of the misunderstandings about patents, and that will ultimately result in profits and increased revenue for your business. Let's answer the first misconception very quickly. We have a lot of ideas, but we need to build a prototype, a working model, or we need to manufacture or create the device or the product. Then only we can file patent for it. Now, this is a misunderstanding, misconception. The patent office do not require the working model in 99% of the cases. If they require it, they would ask separately and we need to produce the working model, but that's very rare. In general, in reality, the prototype is not required. Then what is required for filing patent? Let's assume you have two-liner idea about creating a device, and end result is the product or the prototype or working model that you have created the device. What we need to be able to file patent is something in between, which is called implementable details or something called sufficient disclosure. Sufficiency of disclosure is the requirement. So assuming that you can describe your invention on pen and paper if required, along with the hand-drawn sketches or flow diagram, system diagram, flow charts, or description of the elements, how they are connected to each other. And this description in itself is capable of producing an invention. Let's assume that you have conducted a meeting. Let's assume that you have come up with an automobile device or a mechanical device or maybe a software. You conduct a meeting with relevant people. You hired those people or you hire those companies and you are sitting in the meeting room. Now, all of these people who are going to contribute for your invention, listening to you, and you take pen and paper, you scribble down by pen some diagrams, some system diagrams, maybe flow chart, maybe user experience diagram, or maybe just sketch about the device, how it will look, what are its components, how it is going to function, and listening to you. If the team says, yes, sir, we understood it, and we can produce this invention within 1 month or 2 months, whatever the time frame is, that description, that is called implementable details. Now, if we are talking about software, it could be just the concept, the system diagram and user experience diagram and flowchart. You don't need the source code, the end product. If you are talking about hardware, sketches, hand-drawn sketches, and the components that are being used properly explained, their connection is, the working is properly explained, that is enough to proceed for filing patent. If we are talking about electronics, AI modules, and some additional stuff, electromechanical, then each component, how it is functioning, how it is working, the system diagram, maybe the block diagram, or CAD drawings for that matter, if we are talking about engineering drawings, are enough. And you can explain it in a greater detail, and that's okay to proceed for not only to file patent application and get patent pending number, but also in the examination phase, and also till the grant of patent, and also to the monetization wherein you are actually licensing or selling your patent. This information is sufficient. 99% of the time you would not be required to produce prototype or working model. That's the main misconception that we should be having clarity about. So there is a detailed section in our report, the PDF research report that we have shared along with this video. You can refer to, and there are lots of different videos also explaining the concept in detail. So working model or prototype is not a requirement for proceeding with patent application. Second misbelief, we get a lot of these in business owners and busy people who are at the top of the business. We do get a lot of good ideas, concepts in our mind, but we don't have time for this. We have different priorities. We don't have time to invest in doing the research and then filing the patent for our good ideas. Now, this is a misconception, because when you imagine a patent being filed for a research or for a project or for a concept, you imagine labs, a lot of pages are being handled by a huge team. There is a lot of reading that is going on, continuous discussions that are going on, and then some research work is done, some experimentation is done, and then the patent is filed for that particular invention or product. Which is true, by the way, but not always. In many cases, the patent is filed within few hours of interaction with the inventor. When you have sufficient details of your invention ready with you, as I mentioned in the first point, you don't need the prototype or end result. If you have, that's well and good, but if you don't have, all you can have is implementable details. How the patent, how the invention or how the product can be implemented is very clear with you. And if the patent attorney or IP firm you are working with or patent agent you are working with understands your invention 100% very clearly, he can stand in your shoes and understand what you have invented and what you want to protect with the patent. 95% of your job is done. 95% of your responsibility is done when a patent attorney or IP firm says, we understood your invention, can we proceed with this? Because all the steps after that, like doing the novelty search, prior art search, if it is required, that is an optional step. Drafting a patent application, which takes about 2 weeks of time. Then filing the patent application in the patent office, you get patent pending number, patent application number. It would be published, it would be examined, then receiving the examination report, which are kind of objections from the government patent office, responding to those examination report by written response to first examination report, filing it in patent office, and it would be granted straight away, or we could be receiving a hearing, which is again case to case basis. All patents don't receive hearing, some of them do receive hearing. So attending that hearing and till the grant of patent, all these procedures are handled by patent attorneys, IP firms, patent agents, which are there. If we combine all of these interactions, it would be less than 10 hours of your time. What that means for us is, once you are clear with your invention and once you have definite idea about what you want to produce, you don't need that much of a time. You actually need an intent and maybe 10 hours of your time, so that you can explain to the right person, right firm, and they can take it ahead. Third misbelief, we do have a lot of good ideas about products and concepts in our mind, but we don't have the manufacturing capacity, we don't have the machineries, infrastructure, resources, people required to produce it. then what is the point in filing patent for it? Why to patent it? Now, this is most common misbelief again we have seen in industry owners or manufacturers particularly. But in reality, you don't need to produce the invention that you are actually trying to patent, because you might be having a lot of ideas in your mind apart from the main line of your business. Now, this is something I personally witnessed when I visited a few of the industries nearby Pune area, and the person had drawn a lot of sketches on the board. We happened to see their robotic arms and relevant invention, and then we discussed having tea, how to proceed about it. And then I just, with a curious mind, asked, what is this? What are these diagrams? And they said, every Friday we just do a meeting with our team and just brainstorm some ideas. These are not relevant, we can't implement it. But then these are very qualified, that was very qualified information. The block diagrams, the how it works, the system was very capable information to get patent for it. And they can actually get the granted patent. As I explained in step 1 and 2, it's not that difficult or it's not that time consuming, and they can license it to the people who do have machinery or who do have resources, and they can actually sell it to some other firm and get benefited by it or get profited by it. It never occurred to the person that whatever they discussed in that meeting and whatever they have drawn on the board is actually sufficient. We can take it from that point itself and we can convert it into a patent, granted patent, of course with your help, with a lot of inputs from your end for reviewing the document and seeing the corrections or checking the validity of whatever we have written. But then that thing has potential to become a patent, and then it can be licensed and it can be leveraged for generating resources. So it's a misbelief. You don't need to be having manufacturing capacity or producing capacity to be able to file patent. I hope this misconception is cleared again. And there is a detailed section about this in the report as well that you can refer to. Fourth misbelief, getting patent is expensive. We don't have budget for it. Now, this probably would have been true in past, but now because of the changes in patent law, particularly Indian patent law, MSMEs and startups have 80% fees reduction when they try to file patent in India. So 80% of the government fees is reduced, discounted for MSMEs and startups. So the filing fees is as equal as individual, although it is a legal entity. And this is not just one part. There are lots of subsidiaries and government schemes which can help share the budget for filing the patent, or they can reimburse some value for filing the patent, and it has become super affordable now. You can check the details about the costing for filing patent in India in our PDF report that we shared, and you will see these are absolutely affordable. Fifth misbelief, the patents are lengthy and time consuming. It takes years for patent to get granted, and hence they might not be useful for our industry. Now, it might have been true in the recent past, but recently the patent law has changed. Particularly Indian patent law has changed, and the speed of grant is exceptional. If we compare the speed with other countries, the India is one of the fastest country to grant the patent applications, and we have seen the patent being granted well within 8, 7, sometimes even 6 months or 7 months from the filing date also. That is one side of the answer. The second side is, you don't need to wait for the grant of patent to do most of the things you wanted to do with your invention or patent. Assuming that you are a business owner or a professional or maybe a working professional or a team member and who have filed a patent, all the things you wanted to do with your patent or patented invention, you can start doing immediately after the filing of patent application. When you receive the patent application number, the government receipt, the number would be there, the patent application number, and that is called patent pending status. 95% of the things you wanted to do with your invention, you can start doing, like marketing, talking about it, meeting people and trying to raise funding or finding channel partners, start selling it, start doing business and writing patent pending number on the product or maybe your service or website, and start promoting it without the worry that somebody will see your invention, somebody will see your product and they will try to patent on their own name, or they will steal it, or they will start producing it that is infringing on your patent. Because when somebody infringes on your patent and you get to know it, and you, let's say, let them know that it is your patent and you should not be infringing, because once you receive the grant of patent, you can actually stop them legally. and let's say they continue the infringement, and after the grant of patent you went to court and you actually file a lawsuit against them, then the court can allow the damages of the interim period. So in a way, the protection actually starts when you file the patent application, and that literally happens within 2-3 weeks from the first time you speak to patent attorneys. So within 2 to 3 weeks you get the patent pending number, and from that time itself you are free to do most of the things you wanted to do with your patent. So patent is a lengthy process, it's time consuming, and it takes years, is a big misconception, especially recently, and it has to be cleared with the right information. You can refer to the section on our PDF report again for the timing of the patent, and you can get a very clear idea, and particularly this section about the benefit and advantage of patent filed status or patent pending status. Patents which are filed and patents which are pending, not yet granted, are also licensed for royalties and also sold at certain price if the opposing party or the buying party is interested. That's very normal to see. So you only need to wait for grant of patent if you are to file a case or lawsuit against others, and that's very clearly mentioned in there. So please refer to the section in the report. It's very important to clear this misconception about timing and time required for patent. Sixth misbelief: the patents are for big technology research oriented firms with lots of resources. We are a small firm, we have a straightforward business, we are simple firm, we don't require patents, we have nothing to patent. This is again a misbelief or misunderstanding, because a lot of invention come from normal businesses, or let's say normal solutions. Uh, in reality, there are lots of inventions which are incremental inventions. It need not be anything groundbreaking or you know uh, earth-shaking invention. Incremental invention, solving some problem in some industry, solving some technical problem, making a particular device more efficient, more productive, more faster, more saving energy, saving space, increasing life. If you're doing anything that is even 5% novel and inventive compared to the entire system, it still is able to get patent for it. So what that means is patents are always being filed and granted for incremental inventions. You are improving something in the systems which are already known. You are making it faster, making it quicker, making it efficient, saving some energy, saving some electricity, saving some space, requiring less hardware, or let's say requiring less component, or all the components could be already known, and the arrangement to solve a specific problem is new, novel, and inventive. Again, that still can go for patent. More than 50,000 patents are filed from MSME or small industries in India. And as I mentioned in the previous section, there are 80% fees reduction, government fees discounts for MSME or startups from India. So patents are only for big firms is a myth, is a misbelief that you should not be believing. And there is a section about it in our report. There are lots of examples also wherein the small companies or even individuals successfully come up with implementable details. They have filed the patent, they have got the granted patent and been running successful business out of it, or they have licensed it and made money out of it. Seventh misbelief, and the last in our discussion: patents are waste of time and money. Now, going through all the points from 1 to 6, this might not stand as a point, but still there would be some objections, or there would be some misbeliefs related to patents is just waste of time and energy. It's waste of money, which is not true. Again, it's a very standard and very classic misbelief, because there are some direct advantages of patent and there are some indirect advantages of patent. Now, when we talk about the direct benefit of patent, it's obvious that whenever you patent something, you can build business around it and you can enjoy higher profits, because the patent will have the monopoly and you can stop others from copying it. That's very direct and straightforward. Second, you can rent it. In our language, it is licensing agreement. You can license it to one or many firms, exclusive or non-exclusive licensing. You can sell all together. I mean, you can sell the patent rights all together to a buying company. And when you see somebody is infringing on your patent, you can file a lawsuit and then the opposing party or the infringing party has to pay you some damages as per deciding, as the court decides, or there would be lots of penalties and financial compensation if someone is infringing on your patent. So this is another way of making. So these are direct benefits, but there are some indirect benefits. When you have patent pending or patent number on your product, imagine your product is competing on all the products on Amazon or some e-commerce site, or it is a service. So when you see the patent application number or patent number on the product or patented product for that matter, uh, the immediate reaction from the buyers or crowd would be, this seems to be an expertise in your business. So you will immediately start discriminating, or your business would be immediately elevated in its image in eyes of customers or in eyes of whoever views it. Second, seeing the patent pending number or patented term, the competitors would be discouraged. They would be uh, uh, not encouraged to copy the product, because some people will think, if I copy this, they will come after me and I have to pay hefty charges for infringement. You can actually raise funding based on the patent, because if you see the funding companies or seed funding or someone who invests in businesses, they see patents as an asset. Naturally, they are investing in your business. They would see how the patent will block the industry or how it will create the monopoly, and you would be enjoying the profits for longer duration. And that's a positive sign when we compare to something which is not having patent. They can be used as collateral also. In many cases, we get loans based out of granted patents or filed patents. It can be mortgage for the loan, as I mentioned. Uh, it also strengthens your personal resume if you are filing patent on your own name as a director, as a owner, or maybe as a staff member or employee. So it strengthens your resume. It is considered as a positive impact whenever you are applying for a job or any other opportunities, and it earns you promotions, praises, and recognition in the market when you have your name on the patent. So these are some indirect benefits. Do consider visiting that section. It has immense value if you still believe patents are worthless and should not be invested time and money for. So thank you for your time. Hope you received some value out of this video, and do let us know if it has helped you overcome the misconceptions or misunderstandings about the patent. Thank you so much for your time. Take care.